All right, welcome. I'm Diane Drain, Chair, it's reminding me to turn the recording on, CLE Chair for ACBC. And look, we're going to explain a little bit about why we're here in a minute, but just some housekeeping. Number one, if you have questions, post them in the chat. We'll be watching those questions and kind of weave them in if the topic where Ken is at that time is relevant. Otherwise, we may hold them until after. Documents, I just posted them and I will be posting them again periodically throughout the program. The documents are at the ACBC website. So you just go there and you will see the all the materials that Ken has prepared for us and his slideshows. Lastly, the CLE cert will be posted at the end. Now it's possible, depending, and Ken's the boss here, so depending on how much extra time, we might bleed over a little bit. If so, it's appropriate for you to edit your CLE certificate. Also, just a note, it looks like a couple of people have signed on using their phone number. I can't do CLE credit for a phone number. So you can either email me at admin at acbcforum.org or change your your phone number here on your phone. So that pretty much takes care of it. There he is. All right, everybody. Now the truth of what's really going on here. All right, this has taken some concerted effort to get it together. A little brief history about why we're here. First place, Kenn is just fabulous. He did fabulous work in getting the laws to change so that unconventional homes are not something that the trustee or anybody creditor can take from you. And there's some other important changes he's going to talk about. For those of you that don't really have the history as far as the change in statutes, so Arizona has protected as a homestead mobile homes until February of 24, when the Arizona Supreme Court ruled that a motor home was not a mobile home. Thank you very much. And that meant that the homestead did not apply to those. That was very important for Mary and Steve Drummond. The decision meant their RV that they were living in full-time, no other home, was not protected. And as Mary says, it's not fair. Just because we live in an RV doesn't mean we're homeless. It means we're houseless. So the couple had sold their home in 2018, choosing to live full-time in the RV. And then COVID came along. They got sick, medical, up the wazoo, credit card bills, and they decided they needed to file bankruptcy. So in 22, they filed Chapter 7. And unfortunately, there was a challenge as to whether or not they could protect their RV. It went to the Arizona Supreme Court. And at that time, the Supreme Court decided that a motor home did not qualify for an Arizona exemption, which left the Drummonds homeless. Vice Chief Timmer disagreed. She dissented, saying the fact that a debtor's home has a motor makes it no less than the debtor's home. So Kenn Neeley has been the chair of ACBC's legislative committee for many a year. He took on this challenge because, as we all know, it was wrong. He worked with Senator Carroll, who testified that to the Senate that we want to make sure people who live a lifestyle a little different from a stick frame home should be able to protect the home. He says this is very easy to do. It's a no-brainer, and Kenn did it. So now, Kenn, off to you.
Oh,
thank you so much.
Yeah, so sweet.
Thank you so much. Unexpected, but thank you. I appreciate it.
And I might add, very, very well deserved. Thank you, Kenn.
Thank you.
Beautiful. Thank you.
So, oh, no problem. I'm actually going to jump in here as well. I'm Heidi Neeley. I'm Kenn's wife. And also, I am the only person here who fights more with Kenn than Terry Dake. So that makes me unique. Professionally, I'm a real estate agent, and so I sponsored lunch for everybody here in person. And interestingly, Kenn also recently got his real estate license. I told the folks here because he's not busy enough. But yeah, so we're here today, and I just wanted to make a pitch. We have a full house of people here in the office, and it's so wonderful. I think in this day and age, and with all the things going on in the world, building relationships and sitting face to face with people is really, really important, especially in communities where we have very strong, sometimes opposing opinions. It's really vital. So we're really appreciative of everyone who came today in person, and hope that some of you will come to a future event. So I'm just going to introduce a little bit about Kenn, give you some background. Kenn, your instructor today, Kenneth Neeley, has been practicing consumer bankruptcy law for 17 years. He's been very active in the bankruptcy community, working on various areas, including student loan work, bankruptcy litigation, lobbying, and appeals. His appeals record is 7-0, including 2 cases at the Ninth Circuit. He's currently the legislative chair of the ACBC, and the ACBC was key, as you know, in getting this law passed. So we're super grateful to them and to Kenn for all the work they've done. And with no further ado, I'll turn the time over to him.
Thank you very much. All right. All right. So, all right, that puts me on the spot to deliver something. Hopefully, some nuggets today that will be useful for all of you in your practices and just in your overall knowledge of kind of Arizona's consumer bankruptcy protections, Arizona's consumer bankruptcy exemptions. So we'll jump into that. I did want to show you real quick who is here because, like Heidi said, we have an awesome group of people here. So down there, this is the front row, the A students. All right, and then back in the Mark Ashley's in the back. Not a surprise. But some great people here, and it was fun to see some people in person. We just don't do it as much anymore. We used to be sitting at 341s all the time, and we could chat with each other as we waited for our case to get called, and that just doesn't happen anymore. So I'm grateful to have all of you here that came in person, and grateful to see a bunch of other people online that I haven't seen in person in a long time. All right, so changes ahead in 2 weeks, okay? We'll talk a little bit more about it, but changes ahead. My wife saw the slide and she's like, I thought the law already passed. It did, but it goes into effect on September 22nd. So 2 weeks from today, or September 26th, 2 weeks from today. All right, there's my slide. I'm really happy among all the people that registered and are attending today to see so many people from nonprofit legal services organizations. 10 people from community legal services registered, and 2 are here. People from Southern Arizona Legal Aid, people from William Morris Institute, the Self-Help Center, of course, Tammy, we love. And so help these people out. I'm going to make a little pitch. As bankruptcies are ramping up, they're going to need help. They're going to be busy, probably already are busy. So help them out whenever you can. Take a pro bono case. If you take a pro bono student loan case, if you want to learn how to do that, I'm happy to be a resource for you. So, all right. Yeah, you bet. All right, so the roadmap of what we're going to talk about today. 3 motivating factors that really, hang on, I'm going to just see if I can change that a little bit. There we go. Perfect. All right. 3 motivating factors really that compelled ACBC to take action in this 2025 legislative session. We're going to talk about what those were. I'm going to give you some highlights of the lawmaking process. This CLE is definitely not meant to be nuts and bolts on lobbying or lawmaking by any stretch of the imagination, but I'm going to just give you some of my insights, some of my observations. It was interesting for sure to see. My wife says how the sausage is made. Yeah, a little bit to that degree. So then we're going to talk about the end result, probably the most important part of the presentation. What are the laws going to look like in 2 weeks, and how do you implement those practice tips to make sure that you hit the ground running? And we should have some time, plenty of time for Q&A. All right. I'm happy to, as Diane mentioned as well, take questions as we go. So here in the conference room, just raise your hand. Online, put it in the chat. I have my amazing paralegal right in front of me who will flag me down if she sees a question that should be answered kind of real time as we go. All right. So situation number one that motivated us is the one that Diane gave a really nice overview for to lead us off. So the Drummonds filed bankruptcy in 2022. They lived full-time in their motorhome in Bullhead City. They used the homestead exemption to protect the equity in their motorhome. That wasn't without good legal reason, by the way. In 2003, Judge Haynes ruled that a motorhome did qualify for protection under the homestead statute. So there was law, while not necessarily binding law, persuasive law from our district, from a well-renowned judge. So I filed a lot of cases and used the homestead exemption on motorhomes. Talena's nodding because she knows, and I'm sure a lot of you did. And so, unfortunately for the Drummonds, this is the case where Trustee Warfield decided to take a stand on that. And there were actually a couple others simultaneously going through the courts. And Terry Dake, representing Trustee Warfield, took this case to Judge Sala, and Judge Sala certified the question to the Arizona Supreme Court. That happened in early 2023, and then it took a little over a year to go through briefings and oral arguments. And in February of 2024, the Arizona Supreme Court ruled that motorhomes do not qualify for homestead protection. It was a very text and context-driven, as you would expect from a largely conservative Arizona Supreme Court, a very text-driven analysis. They looked at the categories in the homestead statute. There were the 4 enumerated items. They felt like everyone was real property or permanently something that, even if it was at one point temporary or movable mobile home, it had become permanently part of real property by being affixed and attached to the property. And so they felt like that was just important. Something like a motorhome that could be driven around, they didn't feel could be protected. The word permanent is actually mentioned 43 times in the hearing. So that's how important the word permanent and permanent affixation, I guess, I don't know if I'm pronouncing that right, but to the property was to the Arizona Supreme Court. So the actual language they used was, we conclude that subsection A3's exemption pertains to a permanent fixed structure where a person resides. Thus, a motorhome cannot be a mobile home under the homestead statute because it is readily movable and not anchored to land. Okay, so that's what we ended up with. I'm going to show a couple of videos. I was really close to having Senator Carroll appear actually and give a couple minutes of his own thoughts on sponsoring this bill. Unfortunately, he's out of the country today, and so he wasn't able to make it today. But what I do have is I have a couple short videos. Each one is just a few minutes long. I'm going to show and share through the Zoom because they give some really good context. Diane touched on a few of these points, but I just love the way that they were presented by Katie Wilcox, a really fantastic reporter for 12 News. So I'm going to switch over, and hopefully this will work and the audio will come through.
Right now, it was a very different kind of case that came before the Arizona Supreme Court, impacting families facing dire financial challenges, filing for bankruptcy.
12 News investigative and consumer journalist Katie Wilcox spoke with one woman who never imagined filing for bankruptcy could leave her homeless. Katie?
Yeah, Mark Caribe, bankruptcy is the last resort when debts are too much to handle, but we have laws that protect things like your home from debt collectors. Still, when this couple decided to sell their house and buy an RV, the Arizona Supreme Court had to decide whether or not an RV or motorhome really counts as a home. Life on the road.
You know, we each have our favorite state.
It's unpredictable.
Steve likes North Dakota the best.
But for Mary and Steve Drummond, how many states do you think you've got?
Oh my goodness.
The surprises
We saw a lot.
were part of the fun. It sounds like an incredible journey that you've taken.
It was really fun while it lasts.
It didn't get to last. Barely 2 years after the couple sold their house and bought an RV to live in permanently,
We got COVID ourselves.
they got sick
We were both in ICU at the same time. He's on one end of the floor and I was on the other end.
and struggled to pay the bills. On top of credit card debts, nearly $8,000 in medical bills left them feeling they had no other choice. In 2022, the Drummonds filed for bankruptcy, never thinking they could lose their home, the motorhome.
Yeah, so the Drummond case is a case that's been going for quite some time.
Attorney Ken Neeley is not involved in this case, but he became interested after the Arizona Supreme Court got involved.
In the law, it says it protects a home or a mobile home, but it doesn't say motorhome.
And so the question in this case was whether or not the motor home, which the Drummonds owned, was the same thing as a mobile home.
Terry Dake is also a bankruptcy attorney in Arizona.
It's a big deal because, the legislature has always found it important to protect people's homesteads, that they don't want people put out on the street by their inability to pay their debts.
Dake is directly involved in this case, representing the trustee, who believed the RV should not be protected by the homestead exemption. The court agreed.
I think they missed the entire point.
For Mary, the decision came as a complete shock.
Do you think of your RV as a vehicle or a home?
It's a home.
For Dake and his clients, the law wasn't so clear, and the court said it can't rewrite the law. It defers to the legislature to modify statute if lawmakers disagree with their interpretation.
If the legislature doesn't like that, if they don't think it's appropriate, it's up to the legislature to make that change, not the court.
Do you think the legislature will take this up?
Absolutely. I'll intend to introduce legislation in our next session, probably with an emergency clause attached to it to be responsive to the Supreme Court's decision.
Arizona Representative Matt Gruss, a Republican from Scottsdale.
But at the end of the day, we're talking about someone's home. We have to have some recognition of the humanity involved in these terrible situations.
Mary spoke with me over Zoom because she and Steve are now living with their daughter out of state.
It's not fair. And just because you live in an RV doesn't mean you're homeless. It just means you're houseless.
Without your RV, where does that leave you?
Out in the cold, living in our car.
They are expected to surrender their RV. Right, and I spoke with Mary again this morning, and she said that she and Steve have turned over the keys to their attorneys.
It sounds like someone's playing games with semantics, Katie. Just how many people does this Supreme Court ruling impact?
Right, so, nationwide, we can estimate that maybe 100 to 200,000 people live full-time in their RVs. It's a relatively small community, but right now in Arizona, I'm told that there could be between 5 and 6 cases currently in front of bankruptcy courts, all of people who right now live in their RVs, all of who could be facing homelessness themselves.
Wow.
Yeah,
Sad.
terrible position to be in, that uncertainty. All right, Katie, thank you very much. And by the way, we first learned about this story from a viewer tip to Connect at 12 News.
Okay, so there was a follow-up to this. So
12.
I'm gonna just play.
Suit the other driver after a comments. There's a better way to get paid a way bigger check without having to go to court or pay expensive upfront legal fees. Listen, if you've been in
Just a few seconds of the follow-up. So the first story came out shortly after the Arizona Supreme Court ruling. I reached out to several news organizations and this one picked it up. And then when we found a sponsor and we started into the process of seeking a legislative change, they did a follow-up. And I'm just going to show the last 60 seconds of this one. So I don't want to take the whole time with videos, but this is kind of a great last few seconds of this follow-up video.
Decision, the court said it can't rewrite the law, adding lawmakers will have to make changes if they disagree with the court's decision.
I appreciate the court deferring to us. They don't do that enough, in my opinion.
On Monday, Senate Bill 1540 was the first step to do just that.
But it does mean that sometimes we've got to then step up when they do, which is what this bill does. So thank you, Senator Carroll, for bringing it. Thank you to Channel 12 News for raising awareness on the issue. And I vote aye.
Passing the Senate Finance Committee unanimously.
It's kind of what we expected. We try to do our best for the people. And this is a no-brainer. It's pretty easy to do.
Katie, it is kind of a no-brainer, especially in a place like Arizona when so many of our residents come here on a fixed income, they're retired, they live in a motorhome. So what happens now?
So, right, this next steps is that it's gonna go to the House or to the Senate floor first, and if it passes there, then it can go over to the House. So this could be a little bit of time in this process. We won't know anything right away, but ultimately.
Okay. So,
They all get what they're.
oops.
Become a new law.
Good work.
Close that and get back to the slides. Okay. So that was risky to try to go multimedia. I think we made it at least with some with a few minor challenges. All right. So, but I wanted you to see that because it's such a good job of illustrating the human side with Mrs. Drummond talking about the impact it had on her family. Seeing our sponsor, Senator Carroll. Senator Gress actually did not end up sponsoring it. A year earlier, he had said, I'm going to bring it. I'm going to do an emergency clause. We waited a little bit long, unfortunately, to get over to his office and to get a sponsor lined up. And so we ended up not being able to work with him. But we found Senator Carroll, who I think was the absolute perfect sponsor. I'm going to talk a little bit more about him in a minute. But these videos, I just felt like I couldn't explain it as well as Katie did and Mrs. Drummond, and seeing Terry talking about sort of their position on it. And I loved the committee. I was there testifying. In fact, that clip of that committee chair saying, I appreciate the Supreme Court deferring to us, was right after I had read that quote that Katie said, the lawmakers are going to have to fix this. I read that as I testified, and he said, well, I appreciate that they're doing that. We don't get that enough. So we had quite a bit of success right from the get-go with this bill, which was good, which was great to see, which is very encouraging. All right. So that's situation number one. Situation number two is another homestead case, but this one has to do with equity in the homestead. And this is a case called Ford v. Poneth that went all the way up to the Ninth Circuit. Ms. Poneth filed bankruptcy in 2022. Her original attorney that filed bankruptcy for her was David Allegrucci. He exempted her homestead by checking the box that says 100% exempt up to any applicable statutory limits. This ultimately led to a standoff between the debtor and the trustee on how to value real property, on the proper way to exempt it. And that issue ended up going all the way up to the Ninth Circuit. After all the briefing and all the oral arguments were done in the case, unfortunately, Mr. Allegrucci passed away and never heard the ruling. The ruling that came out in October 2024 was that the Ninth Circuit found that all post-petition appreciation of a property would be property of the estate, and that the only proper way to exempt a homestead is to find the equity at the time of filing, and that's your maximum exemption. So it didn't matter that Arizona's exemption at that time was $250,000 and now is $425,000. That doesn't matter. If you only had $5,000 of equity on your filing date, then you're only allowed to exempt $5,000. And if it goes up to $50,000 or $500,000 over the course of your bankruptcy, then that value inures to the bankruptcy estate instead of to the debtor. And so it was a really surprising ruling when it came out. It got a lot of attention from consumer bankruptcy attorneys. And it was, I guess I wouldn't be going too far to say it was shocking to us. And it really, to me, was, we knew we wanted to go to the legislature on the motorhome issue already. That was already an existing issue. But when the Ford v. Poneth ruling came out, to me, it made it like urgent. It was compelling because the motorhomes will affect, I don't know, maybe 100 or 200 people a year, possibly, right? To not be able to exempt, and it's a big deal. I'm not saying it's not a big deal. I'm just saying it's a smaller subset of bankruptcy filers, where the Ford v. Poneth case now affected every single homeowner filing bankruptcy. We had this, and still do, because there's still 2 more weeks of that being valid law. We still have this very difficult situation where we have to decide, do we file a motion to compel abandonment? Do we take the chance that the market could turn? Right now, the market's soft. It's maybe even pulling back a little bit. So no big deal, right? Nobody's getting post-petition appreciation, but that could change at any time. And as soon as it does, what do? Then do you file the motion to compel? Now the trustee might object. It's an administrative nightmare. It's a case management nightmare. It's a nightmare for the debtors. And so that to me was just a super compelling reason to get in front of a lawmaker and to try to combine the motorhome and this new post-filing appreciation issue. I don't think, in fact, I'm almost certain Ms. Ford didn't set out to turn the law on its head. This was a battle on principles between her and her attorney, Patrick Dirksen, and David Allegrucci, that just ended up getting all the way up and getting a judge that decided, I'm going to further sort of narrow homestead protection in Arizona. He didn't like the Judge Bybee, I believe it was, who wrote the majority opinion, didn't like the word equity that I say didn't like. He really focused in on the word equity used in the exemption and talked about how, well, that means just a dollar amount. It doesn't mean a piece of property. It means a dollar amount. And he's right. Our homestead exemption is a little bit of a hodgepodge of like several different laws that were put together and amended over years. And there are some confusing references to equity and value and just weird definitions in there. The whole thing at some point just needs to be rewritten to be much more clear. But yeah, that's what the judge in the case used is just that fact that we tie our homestead protection to equity instead of to the piece of property. All right, and then the second closely related case is a case called In re Castleman. In re Castleman is from 2023. In re Castleman is also a Ninth Circuit case, and it held that when a debtor converts from Chapter 13 to Chapter 7, if there has been post-filing appreciation of the property during the pendency of the Chapter 13, that is property of the Chapter 7 estate that's created upon conversion, okay? There's a very strong, long, compelling, well-written dissent that I think is actually the correct legal analysis, the dissent to that. But it was just the dissent. That was the minority. The majority held that appreciation would be property of the Chapter 7 estate. So it creates a disincentive for filing Chapter 13, which is definitely not within Congress's intent to try to encourage people that are filing bankruptcy to do Chapter 13. We see so many incentives to file Chapter 13. You get a broader discharge. There are credit reporting advantages and different things around Chapter 13 that you don't get in Chapter 7. And yet here's now a reason why you might say, well, sitting down with a client, well, sir, I don't know if I would file Chapter 13 in your case, because if something happens and you have to convert to a Chapter 7 and your house is appreciated, then you're going to lose the equity in your house. So we hoped to find a way. And when I say we, I should say, this was ACBC, right? And this was also other colleagues, consumer bankruptcy attorneys that I spoke with, maybe that aren't part of ACBC leadership, but that are either members of ACBC or not even in ACBC. So when I say we, I'm trying to give credit to all the people that contributed ideas and brought up these cases and had some angst around these cases and were talking to me, and we were kind of working together to form strategies. So we hoped we could resolve both of these holdings through a change to the statutes. We didn't know exactly how we would do that, or if it would even be received with any willingness whatsoever, right? We have a majority Republican Senate, a majority Republican House, only barely, right? They're only the 1-seat majorities or 2-seat majorities, but they are majority Republican. We didn't know if we were going to just be running into complete, just getting stonewalled trying to change these laws. So, but we hoped. All right, and then situation number 3. This one really near and dear to my heart, because in 2022, my first foray into lawmaking and lobbying was to pass a statute, propose a statute and lobby for a statute that ultimately got passed in ARS 33-1126 that would protect child tax credits and earned income tax credits. And we were successful. That bill got much more resistance. It was sponsored by a Democratic senator who was very well respected, but just any bill that's sponsored by a Democrat in Arizona, at least over the last many legislative sessions, it's just going to get a lot more scrutiny. It's going to get some pushback. It's going to be looked at very carefully. But he was a bulldog. His name was Senator Bowie. He's not in the legislature anymore. He took this as like his mission to get this thing passed. It was amazing. And so he fought. He even, as part of the budget reconciliation process that happens at the end of every legislative term, he, working with other Democrats, they were making concessions in the budget in order to get this passed. That's how important it was for them to get this passed. So it passed in 2022. There, I could spend a whole CLE telling you all about the crazy things that happened after that, because Prop 209 passed shortly thereafter, which also completely rewrote 331126. And so all of a sudden, did our law get overwritten by Prop 209? Even though Prop 209, it didn't exist when Prop 209 was drafted, but it did exist when Prop 209 was passed. So was it repealed? Was it implicitly repealed? Is the legal term that I learned very intimately. I now know more than I ever wanted to know about implicit repeal. And we went to the Arizona Supreme Court, and they did find that it was not repealed by a very slim majority, 1-person majority. So the law held up, but the problem is, so we thought, yay, we got it. The law's there. But Prop 209 created so much confusion with like this version 1 and version 2 of the bill. And then also this word right here, which if you can't see because it's kind of small, it's the highlighted word is refundable. Okay. And I wrote this, I drafted this law. I have beaten myself up over using that word. I assure you, it's a term of art in the IRS code, right? A refundable tax credit is a tax credit that you get even if you haven't paid that amount of taxes. In other words, it's treated just like you sent a check for, if you get a $2,000 child tax credit, it's just like you send a check for $2,000 to the IRS. And then if they say, you don't owe any taxes, Ken, thanks for sending us a check, but you don't owe us anything, so we're going to send you the whole $2,000 back. That's what a child tax credit does. Imagine someone with a $2,000 child tax credit, but doesn't owe any taxes, hasn't paid anything in. They're just a zero, they're 0,000, but they have a $2,000 child tax credit. They're going to get a check for $2,000. It comes out of the treasury, right? It's like paid to them. It's a public assistance. And even if you go back to the legislative history and the policies and everything of the child tax credit, which was passed during a Republican administration, by the way, Ronald Reagan, and then further additions and stuff were added by Republican administrations like George Bush, older, and George Bush younger. And so this was a public assistance type of tax policy that was designed to help people that needed a little bit extra in their tax refund, right? So it's very, very close to welfare in the purpose that it was served. The different Republican presidents and Congresses that passed it didn't want to just have welfare, but they did want to find a way to help people. So that was our argument to get the bill passed, was why do we protect welfare, but we don't protect this? It's essentially the same thing. And again, with a hard battle, we got it through. But this refundable word was a sticking point, and the trustees would say, and unfortunately, a lot of times when someone is entitled to the child tax credit, a lot of it isn't refundable. It comes above the line, which just means that it's crediting towards their taxes. It's still a refundable tax credit, but see, I said refundable portion, right? So I actually should have highlighted both words. Both words are terrible words. They shouldn't have been there. I was borrowing some language that I had found elsewhere, and I shouldn't have put refundable portion, but I did. And so the refundable portion arguably is the part that's below the line, and that's usually a much smaller amount of the child tax credit. So you'll usually see something like 2,000, 4,000, 6,000 above the line, and then maybe only like 300, 800 below the line, right? And that several of the trustees were arguing that that's what should be protected. Now, there are very good counter arguments to that. The best being, in my opinion, that, well, there's really two that are in the plain language. For example, it says the amount of the exemption is the total amount claimed, right? It doesn't say the amount claimed above the line, the amount claimed below the line. It's just the total amount claimed. And then also this whole second sentence The amount of the exemption shall be the lesser of the total combined amount of the federal and state tax credits, or combined amount of any federal and state income tax, or the amount of the refund. There's no reason for that. This takes a little bit of, anytime I would try to think about this, it would make my brain hurt a little bit. But if you think about it, if you think the only refund is the refundable portion, therefore, there's never going to be more claimed than the refundable amount if you take the trustee's interpretation, right? Because the above the line part is never going to turn into a refund. It's not refundable. And so you could, if the trustee's interpretation is correct, you could literally, you would never have to use the second sentence to determine the amount. And that's a very strong statutory interpretation argument. And that is, legislatures don't write words for no reason, right? They're lazy. I don't know if that's the reason, but they don't put a bunch of language for no reason. There's a reason for the language. And if it never, ever is effective, you never have to use this sentence, then you're not interpreting the first sentence, right? That's my argument. Yeah, Andy.
Does that second sentence let somebody intentionally overpay estimated taxes?
Yeah.
That money could have been taken away from them in bankruptcy, but then they get it as a refund, so it's exempt.
Yeah, great question. So the question is from Andy Jacob here. He said, could someone over withhold in order and then file bankruptcy, and then when they get their tax refund, does that second sentence allow them to keep the whole refund? It does not, because it's only the amount of the claimed child or earned income tax credits. And so you are limited by the credits. Yeah, if you over withhold, and that's still going to be the law in 2 weeks too, by the way, we'll see the law in a second. But if your clients over withhold, they're still going to lose that, or at least the prorated portion of the over withholdings. But now with the way the law is, it should be, hopefully, fingers crossed, that with this language removed, it will be very clear that it's the full child tax credit and the full earned income tax credit. And even potentially the Arizona, they're much smaller, but there's some Arizona credits. They're like $150, $250. We didn't specifically mention them because we didn't want, it was a strategic decision that we didn't mention them. We didn't want to raise potential objections by naming the Arizona credit here, but it says all state credits. So I think there's a very good argument that that small Arizona one is also protected. And a lot of our trustees are giving us that. They're just, when we get the calculations, it includes the Arizona one as exempt. So a lot of the trustees are giving us that. Okay. Great question. Thanks, Andy. So some highlights from the lawmaking process. Let me see where I am on time. Okay. Just a few minutes behind. So I'm going to go quickly through this because the key here, really the key was finding the right sponsor. We had the right sponsor in 2022 to get the first version of 1126 A11 passed. But we really had the right sponsor on this SB 1540. Senator Carroll, I wish he could have been here, was just absolutely amazing on this bill. He's a Republican senator. He's very well respected. We just got the benefit of the doubt from every single Republican. And of course, we're going to get support from the Democrats because it's helping Arizona consumers, protecting assets, things like that, right? So it was, the credit needs to be given where credit is due to our lobbyist who we engaged to help us get the sponsor. Her name is Pele Fisher. She was going to be on. Unfortunately, she texted me and said she's had an emergency with her dog, unfortunately. But so hopefully she'll be watching the video. And Pele, if you watch the video, you're amazing. She just got us hooked up with Senator Carroll, and he ran with this bill from the beginning. As you saw in the videos, we got public attention. Public attention is super important to get traction. We had people testifying at every committee hearing. We had Ms. Poneth, who I brought up earlier, was at that committee hearing that you saw a short clip of in the video. She gave awesome testimony about that portion of SB 1540. So public attention I think was super important here. You saw Senator Carroll, they grabbed him in the hall. Katie grabbed him in the hall. Tell me about this bill. And he's like, it's a no-brainer, right? He gets to kind of be the face of the bill and get some credit. And it's just key to getting a law passed. So getting through those committees, we had indulge me, this is a little bit of bragging. I try not to brag in these, but we got past the Senate Finance Committee 7-0. We got past the Senate floor 29-0. We got past the House Commerce Committee 10-0, the House Rules Committee 8-0, the House floor 55-0. And then it had to go back to the Senate just for a concurrence vote because we actually combined 3 bills into one. So the language didn't change. Actually, I think we might have changed a couple words, but it didn't really change, but it went back to the Senate. And interestingly, it got 26-3 because you may remember it passed 26-3, which is still amazing. But you may remember there were a couple weeks there where the Democrats said, we're going to vote no on any bill sponsored by a Republican until you compromise on the budget with us a little bit. And so 3 Democrats voted no just because it was sponsored by Senator Carroll. But otherwise it would have been a unanimous run all the way through, which is just, it's nearly unheard of on a bill that does have some argument for some sort of partisan siding, right? It does have that for sure. It wasn't a highly contentious bill. I think, as you heard Representative Gress say, it makes sense. We don't want to put people out of their homes. But it still is a bill that could have gotten some contention, and it fortunately did not. Okay. Yeah. So here's the end result. Okay, so we have 3 new laws. They were actually 3 separate bills at one point, but they were combined all into SB 1540 before final passage. A3 changed to say that now, in fact, A3 was stricken. So A3 was the one that just said a mobile home and didn't have on the property plus the property. It just said a mobile home. So we struck that, and we struck A4, and we just moved A3 up, and we wrote a mobile home, park model trailer. Sorry, I actually read that out wrong. So we added park model trailer, motor home, travel trailer, fifth wheel trailer, houseboat, manufactured home, or other form of shelter in which the person resides plus the land on which that shelter is located. Okay, so a clear rejection by the legislature of what the Arizona Supreme Court wanted I guess I shouldn't say that's what they wanted the law to be, but how they interpreted the law. So this was a clear action, let me say it this way, a clear action by the legislature to say, we want the law to protect motorhomes. So maybe that wasn't how it was supposed to be before, but we want it to be that way now. All right, did we make an oops on language? So let me go back so you can see the language again. So see the word plus right in the middle? Again, probably going to beat myself up on drafting this, but I did run it by lots of people, lots of you all could have noticed the plus too. I sent it out to ACBC, listserv. Okay, but here's the problem with plus. So retired Judge Curley has a Substack, which is like kind of a blog where she writes about legal opinions. It's actually pretty cool. There's a link to it in your resources. You can go and you could subscribe to it. And then when she posts new things, you'll get a notice that she posted. And she writes some really interesting articles on there. She wrote about this law and she said, the new law appears to have several ambiguities. Although there is just one paragraph that refers to many different types of shelter as being exempt if a person resides in one, there is the statement that it is the shelter plus the land upon which the shelter is located. Why the word plus? Why not just expand the former paragraph to state that a mobile home, motorhome, or any manner of shelter is exempt if the person resides there? Okay, we could have done that. The paragraph 3 before just said a mobile home. We could have said a mobile home or motorhome or a houseboat or a, but we actually wanted to make it more clear that it was all of these items and the land on which they resided if applicable, but we didn't say if applicable. And Judge Curley pointed that out. She said somewhere in this article, it's not part that I highlighted, but she said, why not just say, if applicable, the land on which it resides, which we should have done. Now, she says the Drummond opinion puts a lot of weight in being permanently attached. And so now we have this problem that you're going to have, how is a motorhome permanently attached to the land? How is a houseboat permanently attached to the land? Is it taken out of the water? Is it put onto a foundation? Now, I think, and I'm going to give credit to April Maxwell on this, who's a fantastic has a fantastic legal mind. I think that Judge Curley, I agree with April, I'm gonna read her analysis, but I think that Judge Curley misses the vote, pun intended, a little bit. Okay, so because here's the thing, the legislature is not trying to reconcile the statute with Drummond. The legislature is saying, we want to protect houseboats and motorhomes and yurts and anything that the person lives in as their residence. And so we're not trying to reconcile the new statute with Drummond anymore. Drummond, except for one little piece that I'm going to talk about later, Drummond is not law anymore. The statute has changed. So we don't have to reconcile with Drummond. And that's what April's analysis is just, it doesn't matter if the ASC, the Arizona Supreme Court, was worried about someone, because in their opinion, they said, what if someone is about to file bankruptcy and they take them and they buy a motorhome and they drive it and they put it on a piece of land and they buy the land and now they can protect it as their homestead? What if they do that? Saying this like, this is such a terrible thing. Well, the legislature said, let them do that. We want them to do that. Let them do that. If that's going to be their home, let them do that. Just like sometimes we do pre-bankruptcy planning where someone buys a house and they move into the house and then they file bankruptcy. Is that a terrible thing to own a home? I think it's the policy of a homestead exemption, right? I don't think it's a terrible thing. Andy?
Do you think the RV has to be located somewheres in Arizona? What keeps someone from having a homestead be an RV in some other state?
Yeah, there are going to be, so Andy asks if someone could own an RV and be in another state and protect it with Arizona's homestead exemption. There are some very interesting extraterritoriality questions that are probably going to come up. I don't think there's an answer to that question. I think that's going to need to be decided and figured out. Does extraterritoriality apply to a motorhome or a houseboat that's in a lake or river in a different state? I don't know. I mean, it's not in the statute, right? So it's going to come down to case law. And Arizona does have pretty good extraterritoriality laws on homesteads. And if you're interested in that, talk to me. I can give you a couple cases. There were a couple rulings that we got on that issue. So yeah, it's gonna be interesting. And Judge Curley says that in her article. There's just going to be some more litigation around it. There always is around the homestead. It's the biggest exemption. So there's going to be litigation around it. Jim.
Remember, Colorado River is an international waterway.
Yeah, Jim says, remember Colorado River is international waters. So there you go. Does extraterritoriality apply to international waters? We may find out someday, Talina, yeah.
So there's a question online, in
Okay.
the original version of ARS 331101A, how did the court distinguish the language in A3 versus A4?
In the original language, A3 was just a mobile home and A4 was a mobile home plus the land on which it resides. So the question is, how did the court distinguish those two? In Drummond? So in Drummond, what the court said was, they kind of said those are the same thing, honestly. It's the only difference is the person doesn't own the land, but the mobile home is still permanently affixed. It's not going anywhere. It's tied into utilities. It's on a foundation, but you're renting the land. You can still protect your mobile home. What's your mobile home worth when it's in that, when it's attached to land you rent? Not a lot, but you can at least protect the home itself, right? Or if you do own the land, you can protect the home and the land. So yeah, good question. All right. End result on our second issue, this was the Ford v. Poneth issue, okay? This was the issue around post-petition appreciation of the homestead. And this is our new law. It's long. I won't read the whole thing to you. Actually, I probably should at least read part of it though. So the key, you know what, I'm just gonna paraphrase because it's in your materials. You guys can read the whole thing. But here is the key to this statute. And this is maybe the biggest kind of, the biggest like windfall we pulled off through the statute as we got it through the legislature, is we were able to convince the legislators to pass a law that if the homestead has less than the homestead protection amount, so in the statute, the word that's used is equity. If the equity is less than the homestead protection amount, which right now is $425,200, on the petition date, then the property is 100% exempt. We're no longer worried about equity. Now it's just 100% exempt. If it goes from $425,100 on the day you file, fully protected. If it goes up to $800,000 of equity during a long Chapter 7 case that takes 3 or 4 years to administer, doesn't matter. 100% exempt, all the debtors' equity, according to the wording in the statute. Is this going to get challenges? Probably, because it's a big deal, right? This is taking away a lot of potential non-exempt equity from bankruptcy estates. But the lawmakers that we talked to about this were all in on this. So I'm telling you, like, if there are problems with this, again, legislature changes a lot and stuff, but I believe if we get problems, we'll be able to change wording, because they were like, there is no this was appalling to many of the lawmakers, that if a Chapter 7 is held open for 3 or 4 years, that benefits the trustee and the creditors to have an incentive to drag it out and hope that the market goes up and take equity from a house. That was like Republican, conservative, liberal, Democrat, didn't matter. Independent, I don't know if I talked to any independents, but no matter who I talked to, it was appalling to every single one I talked to about it. They didn't like it. They said, you should get what you get on the day you file bankruptcy. The snapshot rule, but it shouldn't be the snapshot rule in the debtor's disadvantage like it is in Ford v. Poneth. It should be the snapshot rule should mean it's protected now forever if it was protected on the day you file. We think that will roll over. We hope that will roll over also to conversions and overrule the Castleman holding. But again, just be careful. This is going to need to be tried and tested, and make it. Some cases are going to need to make it through. Haynes.
As far as marking Schedule C for the new exemption, is there any strategy on how to do it as opposed to a capped amount in case it exceeds it?
Yeah, good segue, Haynes, because we're going to get right into that in about. So Haynes was asking, how should we schedule it on B and C? I'm going to show you the language that I recommend. This is bankruptcy law, the bankruptcy gospel according to Kenn. You can take it or leave it, but I'll show you how we plan to list it. But just let me get through this real quick, Haynes, and then I'll get right to that. Okay, so the end result for 331126A11, this is the tax credit exemption. End result is no more refundable portion, gone. And a couple other clarifying terms in there just to make it clear that it should be the whole amount of the credit. Okay. All right. And we got a little bonus as part of this. This wasn't even our idea. This wasn't anything we asked for. But as we took the bill to Legislative Council, they said, there's this version 1 and version 2 that Prop 209 created that's super confusing. Why don't we just repeal all of version 1, all of our old law, and put anything we want to do into version 2 so that there's 133.1101 and 133.1126 that everyone can rely on and knows is the law. And so that will happen on the 26th. You'll see these in the bill, these two phrases that say version 1 gone. So we only have version 2 now, which is the Prop 209 version, and these will be added into the Prop 209 version. Okay. All right. If that was super confusing, I'm sorry, I got to get quickly through it, but you're welcome to reach out to me about that whole debacle with the version 1, version 2. But I want to have enough time, which I should, to cover these practice tips. So first one's a little obvious, but I put it on there. Just hold filings till the 26th if this is an issue, homestead issue, tax credit issue, motorhome, of course, wait till the 26th. No reason to file now if your clients have a motorhome and that's their homestead. Here's the language I recommend. You'll get these materials. They'll be on the website, and we'll, not sure if they get emailed out, Diane, but anyway, they'll be on the website for sure, Haynes. So I recommend on the homestead, I recommend everybody start putting in the description. You can add to if you use best case, probably in Jubilee and others, you can add to a little comment to the exemption. I recommend you reference that trigger that it was 100% exempt on the petition date, therefore, or it was below 425,200 on the petition date, therefore it's 100% exempt. Do you absolutely have to do that? No, it's in the law, right? But I'm just like making my position very, very clear that the trigger was satisfied. If you disagree, Mr. or Mrs. Trustee, please object to this exemption if you disagree. If you don't object, the trigger is satisfied and the property is 100% exempt, okay? And then I put over in the description, we're going to put the equity on the petition date so that it's clear that it was below 425,000. I think that really puts the trustee on very, very clear notice that if they disagree, they need to object. And if the objection period passes, you're 100% exempt. And then on the tax credit, This is just the language we use to make it really clear our intentions. We also, this is the Schedule C, by the way. We also on Schedule B will put the portion of the tax credit that is estate property. So we'll say something like 70% of the potential 2025 tax refunds not attributable to the child tax credit or earned income tax credit. Use the same language, but not attributable to that is estate property, so that the trustee knows, okay, there might be some overwithholdings, and if so, they're not trying to exempt those. That's on a different line, no Schedule C, no exemption. And then the line that we are protecting, the child tax credit, has a Schedule C entry, okay? All right. Oh, 1 o'clock exactly, we made it. So let me show real quick so that it gets recorded, the disclaimer for Arizona Consumer Bankruptcy Council on the getting credit for this, but now I'll go back to my contact info. So we are done. You guys got an hour of CLE credit, hopefully, and hopefully learned at least 1 or 2 things. There's so many amazing attorneys on here, by the way, that I feel like you should be teaching me and us and not me teaching you, but I hope you got something out of it today. Any other questions before we wrap at 1:01?
This was terrific. Thank you very, very, very much.
Thanks, Carl.
Absolutely.
So I'll close just by saying this, which is I love practicing bankruptcy law in Arizona. We had in our Arizona Consumer Bankruptcy Council board meeting a discussion about how great it is to practice bankruptcy. How do we attract people to practicing bankruptcy? Because it's so unique. It's just so different than family law and personal injury and these other areas, in that we have people on this call, a bunch of people that are creditors' attorneys. We have a trustee. We have people from other litigation practices that are learning bankruptcy, lot of big variety. We can all get together, we can have civil discussions, we can argue the law, but we don't turn it into anything personal, anything like contentious or nasty. And unfortunately, like there are a lot of areas of the law, even in Arizona and definitely in other states, that get that way. Personal injury gets that way, sometimes family law for sure. So I love practicing bankruptcy law, and I appreciate all of you for being the kind of people that make it such an amazing area of practice. So thank you so much.
All right, and everybody, we have a few on here that they're on their cells. That doesn't give me the name. So please make sure that you send admin@acbc.forum.org your name so I can get that on our CLE list. The materials, as Ken mentioned, will be posted or already are posted to the ACBC website. They're open forums, so that means anybody can access them, including this recording. It'll take me this weekend to get this converted over, and I'll put that over there. And because Ken is the boss here, he has agreed to let this open to anyone. So if you want to share these videos, the materials, excuse me, then please feel free to do that. So, Ken, Arizona thanks you. I mean, until you guys have an opportunity to see what goes on at the legislature, you will not appreciate what Ken committed to doing and getting this through. So thank you, sir.
And I'll add a little color for people that are just dropping off. I ended up representing Cheryl Poneth after the ruling came and her attorney had passed pro bono. I took her case from the self-help center. She gave me permission to share anything I wanted to about her case, her facts, the end result, and everything. And I just wanted to say, I should have said this in the main presentation, but she ended up able to keep her house. She was able to settle for a very reasonable amount. Miss Ford and Patrick Dirks and her counsel were absolutely consummate professionals in working that out. They did not want to put her out of the house. They just were fighting for a legal principle. And so she stayed in her house, and she was so grateful for all the help that she got from the self-help center and all of us. And so that's a good heartwarming end result there for her.